Thank you, everyone, for inviting me. I really enjoyed doing this, so really appreciate being here this morning with you. Joseph Hollander and Kraft, that's the legal side of what I do. You might see that sometime branded as JHC Cannabis. It's the same thing. We're just a cannabis legal services division of Joseph Hollander and Kraft, which is a law firm mostly in Kansas, but now venturing into Missouri. So for all of your cannabis legal needs, please email me. The other thing that I do, I have two jobs. The other thing that I do, or I'm starting to do, is I'm the, by default, because no one else in the group wanted to do it, CEO of Vertical Enterprise. Vertical Enterprise is a cultivation, manufacturing, and dispensary company up in St. Joe that has licenses for medical marijuana in all three of those business units, and is planning right now and designing a about 55,000 square foot facility up there to grow and process marijuana, medical marijuana, for the market. Should be operational, we think, by late fourth quarter of this year. What I really like to do, I have about 20 slides, and I'll go through them. It's really a general overview, because it's really all I can do with a presentation. General overview of the medical marijuana framework in Missouri, to give you guys an idea of how it works, or how it's supposed to work, and what point we're in right now in the process. We're fairly advanced, but as you probably noticed, there aren't any dispensaries around. You can't go to a dispensary, even if you had your medical card right now, to get medical marijuana. So we're about halfway through, and it's a real interesting time. I don't really I like doing this, I really love doing this, but I don't like to just stand up here and talk. And I have a hunch that at least some of you have an opinion about some of this stuff, or questions, or have something you're interested in that I'm not touching on. Please ask me, because I just think it's much better to interact with you. Let me move that. Rather than just kind of get up here and talk. So I think the raising hand method is tried and true. If you guys just stick your hand up, and if I don't see you, yell at me, and I'll answer questions and take comments, and let's kind of do it that way. Okay, so the goals I have for this presentation: answer some major questions. Why should you care? How can one get medical marijuana? Not that you would be interested in that, but maybe you know someone who might be, and this friend of yours is very interested in understanding that. By the way, I do have my medical card, so it is legal for me. I don't have any marijuana on me, but it would be legal for me in the state of Missouri to carry up to 8 ounces of marijuana, which is a pretty large gallon Ziploc bag, about half full. When is adult use coming? Why in the hell did DHSS do it this way? That's the Department of Health. And then probably the one that you guys are fairly interested in, what about work, and how does this interact with someone's employment, and that inevitable HR scenario where someone is in the HR office and they have tested positive or admitted to medical marijuana use, and they show you their card and say, but this is legal, and it's for my medical condition. Some basics before we start, so we all are kind of on the same page. The difference between marijuana and hemp is a very important legal difference. If you saw a hemp plant, and I was just, last week I was at a convention in St. Louis, a medical marijuana convention. There were hemp plants sitting out, just in the open. They look like marijuana plants. They smell like marijuana plants. I cannot tell the difference between a hemp plant and a marijuana plant. If a police officer, and this has happened many times, opens up the back of a cargo van full of hemp plants, he or she is gonna freak out. Why? Because it's gonna look and smell like a lot of marijuana. But legally, there is a big difference, and chemically, there is a big difference. And the federal government really drives this, and the state of Missouri just follows along. But the federal government defines hemp as a cannabis plant, essentially a cannabis plant, that has less than 0.3% of THC, tetrahydrocannabinol, which is one of the cannabinoids that is a more psychoactive chemical in humans than CBD, for example, which would be more of a pain reliever or makes you a little bit more relaxed, sleepy, that kind of thing. Doesn't give you a high. Based on dry weight. So there's the difference. You may have heard of farmers growing hemp in Kansas or in Missouri and having a problem with their crops going hot. What that means is that they've got too much THC in them and they have to destroy the crop. So the process is, if you're trying to grow hemp for whatever, CBD or rope or plastics or whatever fiber, food product, whatever you want to grow it for, you've got to keep it below 0.3% THC. If you don't, it becomes a Schedule I drug and you have to destroy it, unless you're in a state like Colorado that allows you to convert that crop into a THC product. Schedule I drug, by the way, means under federal law, according to the federal government, marijuana has no currently accepted medical use in the country and is highly addictive and highly dangerous. For reference, most opioids and cocaine are Schedule II. All right, so why do I care? I don't want medical marijuana. You do what you want to do. I'll do what I want to do. What difference does it make to me? Well, I think this chart goes a long way to explaining that. The top chart, the blue, is Oklahoma. Oklahoma, about a year ago, a little bit more than a year ago, opened up its state to medical marijuana in a big way. And Oklahoma did it a little bit differently than you've seen in other states, including Missouri. Oklahoma just said, go for it. It's legal. Do it. And everybody got in the market, and it was a very, everyone for themselves. We're not going to put caps on licenses. Anybody can have a license. If you can compete, great. If you can't, you'll fall out of the market. We're not going to test anything at the state level. Kind of a free-for-all. And it's actually worked okay for them. But what it did result in is kind of a gauge that we can use. They're ahead of us, and again, they've done it differently, but they're ahead of Missouri, a gauge we can sort of use for patient count. So that 19 represents 190,000 patients at the time this was done, which is 12 months out. They're more at about 240,000 patients right now in that state. It is a similar process in Missouri to get certified. Qualifying conditions are similar, I would say, legally. The ease of how you can do it is pretty similar. So the barriers to entry for a patient in Oklahoma are similar to Missouri. If you take the percentage of population in Oklahoma that has adopted medical marijuana and gone to get their medical card, and you transfer that and you make some adjustments that we think are appropriate, you can kind of predict where we're going to be at a certain time. And so we're about right here. 40,000 patients. And I am pretty confident that in 6 to 9 months, it might take a little bit longer because it's taking a little bit longer for the dispensaries to stand up and for the cultivation centers to stand up. But we will be very quickly, within 6 to 9 months, at 140,000 patients. So that's a real good reason to care, because you're going to be interacting with people who have medical cards. Just a little, this is a chart timeline from the Department of Health on where we've been and what we've done up to date. So the November 2018 is when Amendment 2 passed. It was a constitutional amendment, so your right to medical marijuana is in the Missouri State Constitution now, and cannot be legislatively taken away. December, that became effective. Started taking pre-application fees in 2019. State immediately raised $3 million just by taking application fees for people who wanted to have the chance to file an application for a marijuana facility. Made their rules. Actually, they beat that. They had emergency rules ready before June. Began accepting right at the end of June, actually. They beat this date too. Right at the end of June, began accepting patient applications, and then soon after began issuing patient cards. And then in August was the facility licensing. The facility licensing process began. That ended here in January. All facility licenses have been awarded now. There are about 350 among the different types. We'll talk about that here in a second. Here we are. There are 60 cultivators in the state, kind of. So a cultivation license gives you the ability to grow up to 30,000 square feet of flowering canopy. The way marijuana is grown and the way THC is developed is the marijuana plant is cloned. So you take a cutting, you root the cutting, and then you very soon, once that's rooted, you do what's called vegging it out. So you take it, you put it under a very high-powered lamp, you put as much energy in it as you can to get it to grow as big as you can, as fast as you can. That's called vegging the plant out. And then you take it into a room where it goes from maybe 18 to 24 hours of light to 11 to 12 hours of light. You cool it down a little bit, change the humidity a little bit. That's called a flowering room. Why? Because you're making the plant think that it's fall. And when it's fall, that plant's going to get a little stressed out. It's going to think it needs to reproduce, and it's going to start flowering. And that's what creates all the cannabinoids that you then can harvest and process or sell. 86 manufacturers. Manufacturers do two things primarily. They extract oil and isolates and distillates from the plant. So this has been done for thousands of years, a little more advanced now. But you've heard of hashish or hash oil, same kind of thing, same kind of idea. You're using different solvents or processes to get the liquid part out of the plant, take the solid part, get rid of that because you really don't want it anyway, it doesn't do you any good. And then that's just a more concentrated product with more of what people are looking for, which is cannabinoids. You can then take that, what's called a concentrate, and you can sell that, you can use that, or you can go further and you can do what's called an isolate or a distillate, which is just isolating those cannabinoids more and more. You guys have heard about CBD. It's done all the time with CBD. They can isolate CBD until you have a 95+% just CBD substance. You can then do whatever you want. That's kind of the next part of manufacturing. You then take those substances, you can take those substances and apply them to gummies, other food products, chocolate, brownies, cookies, chocolate bars, beverages. Or you can put them in pretty much anything. Tinctures, lotions. There's anybody have a guess on, and we'll go over this a little bit later, but a guess on what you cannot sell from a medical marijuana perspective, the products that a dispensary is not allowed to sell in Missouri? The state, the Department of Health doesn't say you can't do that, but the Alcohol Beverage Control probably, says you probably can't do that. They have a problem with that. But the answer is pretty much anything. That's actually, I never had that one before. That's pretty good. That's pretty right. Yeah. Well, in some states, Ohio, for example, you can't sell flower for the purposes of smoking because the state of Ohio thinks that's a bad thing. They don't want people smoking marijuana. They think it will cause health issues. That's a big problem for dispensaries and facilities in Ohio because people really like to smoke marijuana. It's a preferred way of imbibing, consuming marijuana. 40% of sales nationally are raw flower or cured and dried flower. Why people like that, there's kind of different theories. The main one is that trying to take the active ingredient out of a plant that has developed over thousands of years to serve humankind and be as beneficial to humans as possible because that's how the plant survives, because it wants to be cultivated, because that's how it kind of keeps going, is dumb. Because the plant itself knows what it can do for humans and how it can be most beneficial. And it's called the entourage effect. Those flavonoids and terpenes and cannabinoids and chemicals in the plant all coming together are better for you, either give you a better high or give you more pain relief or whatever you're looking for, than trying to isolate and rip out certain ones and concentrate them and then put it into a medicine. So you can make the argument that if someone goes in and they want to, they're looking for a certain type of feeling or high from a certain strain, you can't really recreate that by taking out what we think is the active ingredient, THC, and putting that in a certain concentrate and putting that in a lotion or something, or a gummy or something else. Just recently, there was an article a couple weeks ago about THCP, which is a new cannabinoid that we've discovered that is supposed to be 30 times more effective than THC. Just to show, and the point being that we don't really understand how marijuana works completely. We probably don't understand most of what we need to understand. Whether you like it, whether you hate it, the plant probably does a better job of giving people what they want than we can. All right, enough about that. Dispensaries 192, those are located across the state. There are 24 per congressional district, 8 congressional districts. I think there's a map you can find online that's pretty good that'll show you where all the dispensary licenses are currently. I think the Kansas City area has about 40, maybe a little bit more. Okay, any questions so far? No question.
I have a question.
Yeah.
About the licensing. So we have a couple members that applied for licensing but didn't get it. And there's conversation about their application and others' applications were the same. They hired a lawyer to fill it out. Do you know any information on, what that is about? And
I do. So on my foot in the legal services world, most of what I'm doing right now is handling those appeals for people who applied for licenses and didn't get them. It's tricky. It's sensitive. I had a settlement conference with the Department of Health in Jeff City yesterday on one of these cases. They're not happy. They have, as of yesterday, 845 appeals to the Administrative Hearing Commission. That is more than triple what the Administrative Hearing Commission would get for an entire year for appeals. So the AHC, we call them, they're not happy, they're overworked, they're grumpy, nobody knows what to do. It's a real mess. The only other thing I think I can say in this setting, just because you start to get in the weeds real quick, but I filed a bunch of these, and I am one of the department's biggest critics. I have pointed out every time I think they made a mistake in rolling this program out, I've pointed that out. I've written them a letter. I've written articles on it, on the mistakes I think they made. And Lynn Fraker, who's the director of the marijuana division, is probably not super happy with me and the criticism I've given him. But I will say this, and I think it's important to say this in public, because Lynn Fraker has been grilled over the last 3 weeks at the legislature on the rollout of this program, and he has been called a bunch of names, and he has been told he's incompetent, and they have completely screwed this up. And that's just not true. The rollout of the medical program in Missouri has been the smoothest rollout of any medical marijuana program in the country. It is seen in the industry as a shining beacon of hope on how to do this. The other states have been so disastrous. Missouri did it the best way you could possibly do it, as far as we know right now. So, however you feel about medical marijuana, Missouri can be proud about the rollout of its program. It really was done well. It was done right. And if you're not going to do it like Oklahoma did it, which is just everybody do whatever you want to do, we're not going to look, which I think is probably a bad way to do it, then Missouri really is the only other way to do it that's in any way effective and organized. So that's coming from a big critic of the department.
I have a question on that too. Was there a cap on each of those categories, like dispensaries and everything else?
So the Constitution now gives minimums for the state on how many licenses they have to issue. They had to issue 60 cultivation, they had to issue 86 manufacturing, and they had to issue 192. Those are the minimums for each license type. The department is allowed to issue as many as they want, as they feel are necessary to serve the public and to give ultimate best access to the public for medical marijuana. The whole program is designed around access to medical marijuana, easy access, really. So if the department thought that 120 cultivators would be better, they could have done that. They decided to go with the minimums because they thought that that was the best thing to do, that was the best way to serve the public and allow the greatest access to medical marijuana. There's a lot that goes into this. You would think, well, if you want access, why don't you just give everybody a license? Then you just have a flood of medical marijuana. Well, then we have some black market problems. We've seen in other states that marijuana goes somewhere. It doesn't just get trashed. It gets sold to somebody, and it's usually on the black market. So that becomes a real problem. Nobody wants that. You also have to, it's a little anti-capitalistic, I guess. But in standing up an industry, you really have to try and make sure that these guys can succeed. And so 60 cultivators that are each growing 30,000 square feet of flowering canopy, that is a lot of medical marijuana. And if you bump that up to 120 or 240, you're going to have a lot of failures. And that's really probably not good for anybody on standing up the industry. So they're trying to strike a balance here. I think they did a pretty good job. I passed over this, and I shouldn't have. There's actually only about 25 cultivators, not 60, because you could have multiple licenses. So there are some cultivators out there that have 90,000, are entitled to grow 90,000 square feet of flowering canopy. That is a huge, massive indoor grow, or a greenhouse grow. There are really two ways to do it in Missouri. That, in my opinion, is pretty big, too big, a little problematic. There are all these rumors going around of these guys who won 3 licenses for cultivation, and Now they don't quite know what to do because they were incentivized to go out in central Missouri, maybe in a very low population, very rural area, because the state thought that would be good for the economy. They won their licenses, and now they have the right to build a huge cultivation facility in the middle of nowhere. But for example, about 1% of the power in this country is used to grow indoor marijuana. It's a energy ravenous process. And I don't know if any of you ever had the opportunity to see a grow facility, but regardless of how you feel about it, you should go if you get the opportunity because they are fascinating. It is normally large warehouses that are full of marijuana that have these 30-foot tall ceilings because modern warehouse design, you want to maximize that ability to stack up inventory. They have these really hot lights called HPS, high pressure sodium lights, hanging from the ceiling that have to kind of hang in the middle of space because they're so hot. High pressure sodium lights are like street lights. They're super hot, very bright. That's why we use them. Hang in the middle of space so they don't burn the plants. So they're heating up this room, and in the summer, the room gets way, way too hot for the plants. The plants start to die. They don't thrive. So what do you have to do? You have to have these giant double-decker city bus-sized air conditioning units, 3 of them in there blowing and going the whole time to counteract those lights. Well, these plants need a certain humidity level. And what are those air conditioners doing? They're pulling water out of the air constantly. So then you got to put humidifiers in there. And all of these take electricity, right? And they're all fighting each other. So to put 90,000 square feet of flowering canopy in the middle of nowhere, you've got to have a ton of power. And there's all these stories about guys dragging 1 megawatt diesel generators out in the middle of nowhere so they can run this thing because there's no power grid out there. Okay, this is just my little trying to be clever up here. But there is a possession issue here right now that police, law enforcement are struggling with. It's not that difficult legally, but it's difficult for people to get their heads around. So right now, if you have a medical marijuana card from Missouri, if you have a medical marijuana card from another state, or if you just have a patient qualifying condition physician's certification, which is just a piece of paper from your physician saying, yes, this person would qualify for a card if they wanted one in Missouri. You just have that piece of paper. You can possess 8 ounces of marijuana. That is very hard for law enforcement to understand because they'll stop someone with, that's a very good amount of marijuana. They'll stop someone who has that, and let's say it's in pen form. It's a cartridge, or we call it a cart. Clearly, they got that on the black market, right? There are no dispensaries in Missouri. You can't buy that product here. So that product was obtained illegally. And the instinct of the law enforcement officer is to arrest the person for breaking the law. Based on decades of training, that's what you do, right? Well, under the Constitution, they cannot do that. You have a constitutional right in Missouri to possess black market marijuana. And that's not going to change. It won't change when the dispensaries come up. So even when the dispensaries come up, you still have a constitutional right to possess up to 8 ounces or the concentrate equivalent of black market marijuana under the law. Doesn't mean you can bring it to work, but you have the right to possess it in that you cannot be charged or arrested for that. So what's happened in the last 6 months? Well, the black market has done very, very well in Kansas City. Why? Because people aren't scared anymore. Okay, how would one get it? No one in here wants to know that, but you're going to be forced to learn this. You have to be a Missouri resident. You do not need a prescription. As I mentioned before, all you need is for a doctor to sign a physician's certification saying you have a qualifying condition. What's a qualifying condition? We'll go over that a little bit more in detail a little bit later, but it's pretty much any medical condition. Doesn't really need to be more specific than that. You have to get once you get that certification, you have 30 days to get your medical card. If you want to pay an extra $75, you can have a home grow where you can have up to 6 clones, 6 vegetative plants, and 6 flowering plants at a time, which is a pretty good garden. It will produce a good amount of marijuana. You can purchase when you can purchase, which you can't yet. When you can purchase, you can purchase up to 4 ounces a month or its equivalent. There's an equivalency formula, but I think it's something like 900 gummies a month or something like that. The equivalency really doesn't work very well. I think they messed up the math. It's a lot of marijuana you can have. If you need more, you can have 2 physicians sign off that you can get more, and you get a special card and you can buy more. And then the 6 flowering plants, and then every year you have to do it again. Oh, that $25 fee will go up next year. So there's kind of just a very, very medical, official, certification. So that's what it looks like, the top part anyway. It's got a back on it. But all medical, all good, right? See, there's a picture of a doctor. Medical. Yes?
I have a question.
Sorry.
So I have heard that, oh, sure. So I have heard that if you do get your medical card, you have to give up your right to bear arms. So
that's a great question. That is technically not true. Okay, so if you have your medical card, so let's use me for an example, okay? I can say this on tape. I have my medical card, and I also have a pistol at home in a gun safe. That's perfectly legal. There's nothing wrong with that. You're safe. You're okay if you're in that situation. Now, if I go to a gun store and I want to buy another pistol, I'm going to have to fill out my background check, right? And on that ATF form, it asks me if I use marijuana. And if I lie on that form, it's a federal offense. It's a felony, okay? So I cannot go buy another gun under federal law right now. We're working on ways to figure that out. And quite frankly, I'm guessing that people right now are just lying on that form. But that's the problem, is you really are in a catch-22. If you have a medical card, you cannot legally, through a gun store, fill out that form and buy another weapon. You're just kind of stuck with what you've got. Does that answer your question? No, you don't have to surrender it. And if you went to the police and said, I'm here to surrender my weapon because I'm a medical patient, they would say, you're in the wrong place. Okay, when will Missouri have adult use? Well, some would argue, and have argued, that we've got a pretty robust medical program that is so robust and so focused on patient access that essentially it's an adult use program. That the medical veneer is so thin and the patient population will be so high that in essence we need to admit that people are using this for recreational purposes, not for medical purposes, on whole. I'm not sure we're there yet, but I recognize the argument. It's a valid argument. And here's what it's based on. 2 things. Qualifying condition, there's a list of conditions in the Constitution, but they use an old lawyer's trick, and at the end they give a catch-all, which is, well, it could be any of these things or any other medical condition. Well, living is a medical condition, Walking around is a medical condition in my book. So it's a little tough there to defend. There are some limitations if you have anxiety or a mental condition. Some of those, you're going to have your certification form filled out by a psychiatrist or an MD that has some training beyond just a family practitioner, some training in mental illness. But other than that, to be honest, it's pretty easy to get your medical card. I went in to a doctor. I was honest. I said, I have back pain, it's chronic. He said, no problem. He didn't look at any medical records. He just certified me. And they can do that. The Constitution gives them the ability to do that. And frankly, the Constitution gives me the right to get that certification. The second leg of that stool and that argument that we already have adult use or recreational use is that, as I mentioned before, dispensaries aren't limited in what they can sell. So in some states, you can't sell certain products. In Europe, for example, you actually do get a prescription on medical marijuana, and you get a prescription for a certain strain of marijuana. So you can't go in and buy anything you want. You have to go in and buy the thing that you are prescribed. Just like, if you're prescribed, I don't know, Oxycontin. You can't go in and get morphine. Like, you got to go in and get the thing that you're prescribed. You don't get a choice. It makes a lot of sense. Well, here in Missouri, the way the law works, the way the Constitution works, you can buy anything and the dispensaries can sell anything. So there's the definition of medical marijuana products in the Constitution: capsules, teas, oils, infused products, vape products, smoking products, ointments, balms, transdermal patches, suppository. You have a constitutional right to suppositories, and infused food, and anything else recommended by your physician. I don't know what else there is. Like, humans have spent a lot of years figuring out how to imbibe marijuana. We pretty much covered it there, I think. Okay, so there's criticism. Yes?
So is the potency different between recreational and medical?
No. So what I tell people is...
Is the potency different in medical than recreational?
Thank you. For posterity. That's why we're doing that. No. And what I tell people is there's really no such thing as medical marijuana as a product, particularly in Missouri. The medical marijuana really is a framework for a way to administrate a program. It's a process you go through. You get your medical card. You have to go to a doctor. You have to go through these steps. But there's no such thing as, you don't go to the medical department in a dispensary. Like, no one asks for, I want some, give me 2 ounces of your medical marijuana. It doesn't exist. You're buying the same thing that someone would buy in Colorado, which is a fully recreational market. It's just, there's a little bit more of an overlay, or maybe you could call it hoops to jump through in order to get into the store. But once you're there, and the difference is really taxes and how much you can buy, but it's not in the product. Okay, so there is some criticism of DHSS, as we've talked about. So why did DHSS do it the way they did it? Why did they roll it out the way they rolled it out? I think they did a good job. A lot of people disagree with me. The fact is, they didn't really have much of a choice. The constitutional amendment is 13 pages long. It's not, like we're used to the First Amendment or the Second Amendment. It's a paragraph, maybe 2. People think of a constitutional amendment as a very short thing, recitation of kind of general rights. This is the 13-page, single-spaced, typed amendment that goes through in detail how this program should work. So by the time this got to the Department of Health, it was really dictated to them on what they could do. The only thing they can really do is pass emergency regulations. And I won't go into it because it's boring and we don't need to talk about it, but emergency regulations can only go so far. I mean, they're for emergencies. You don't go through the typical regulatory process where you have comment. It takes 2 years to get these things passed. These are emergency. Well, so you can only do that for certain situations. They really couldn't go outside the bounds of their constitutional mandate. They kind of did what they had to do. They didn't have a lot of discretion. And the mandate was from 67% of the populace. People in Missouri really like marijuana. There's I should have mentioned this at our last slide. There's a ballot initiative. It's called 2020-128. It's gathering signatures right now. It almost certainly will be on the ballot in November, the presidential election, for recreational marijuana. It's polling at about 80% in Missouri right now. And at that point, when it passes, and I'm pretty sure it will, we will have official adult use in the state of Missouri as of December of this year. That's my prediction. Okay, so there are founding fathers of marijuana there. You don't think they used marijuana? I think they might have. Okay. And all of this kind of comes to a head when you start talking about what's recreational, what's adult use, what's medical, what's a medical marijuana product, what's a medical marijuana framework. What you end up coming to is what do you mean when you say medical use as opposed to recreational use? Is there a bright line there? And the way that we've tried to deal with this in the industry side, not the legal side, is to ask people, what do you use this for? Do you use marijuana? And if so, do you use it for medical purposes or do you use it for recreational purposes? And what we found out is people say both. So you'll see these surveys where 50% of people will say they use it for medical purposes and 75% of people will say they use it for recreational purposes, which is more than 100%. It overlaps. So people use it for both. And it is, if you think about it for a little bit, it is sort of hard, especially with mental challenges that some people have or emotional challenges. It's sort of hard to distinguish. And I can give you an example. If you have a stage 5 cancer patient who needs to just escape for a little bit, I could make a case for a 95+% THC concentrate for that person. Even though that doesn't seem like a medical product, I could argue that it is. Now, is there some recreation there too? Sure. But it's not always as easy as it might initially seem to distinguish the two. And certainly people don't make those distinctions. They don't really categorize it that way. There is a section that I want to bring to your attention in Amendment 2, the constitutional amendment for medical marijuana, that talks, it's the very beginning, it's the intro, and it talks a lot about this is going to be for medical purposes only, for people with serious illnesses, that the treatment is going to be under the supervision of a physician, and you can't use it for non-medical purposes. This is very strong language in my opinion, and it really, there's no follow-through. That's the point I want to make to you guys. Is this is not how Amendment 2 works. They put this preamble in, I guess, as a head fake or something, but there is no physician supervision for treatment. Physicians don't recommend a treatment plan. This is very confusing. Yeah, medical purposes, okay, but serious illness is nowhere to be found. That's not, it's medical condition, it's not serious illness, which is different. So just be aware if someone comes to you and says, well, look, this is pretty strong language in Amendment 2 and they're not doing it right, that's where there's 2 paragraphs and then this ends. And then the rest of the whole 13 pages is completely different. And it's really, again, focused on access for patients. Easy access. Okay, I already talked about that. So what about use at work? And people really love to come up with, and we can do this here too, they love to come up with these scenarios about what we don't know or understand about. Well, what if this guy, wrecks his forklift and then he's on multiple medications and one of them's THC and we've got this policy and oh no, what are we going to do? And I'm in this meeting and it's just terrible. And yeah, it is. I mean, all of that could happen, but all I can do as an attorney is tell you what we do know. There's lots we don't know, but here's what we do know. This stuff is in the Constitution, so we know this. You do not have a constitutional right to be under the influence of marijuana when that would constitute negligence or professional malpractice. You do not have the right to be under the influence of marijuana and operate a vehicle, including a boat or a plane. You cannot bring a claim against an employer or prospective employer for disciplining you up to and including termination for working while you're under the influence of marijuana. That's in the Constitution. There's no right to health insurance for medical marijuana, and you have no right to consume it in a public place. So the key here is that you have no right to go to work under the influence of marijuana. So what does that mean? We don't know. There is no test. You can test people and you can tell for most drugs whether they're under the influence to a standard that most professionals would agree they should not be operating heavy equipment, which is usually the problem that we're talking about. There is no test for marijuana, and the problem is it affects the body differently than alcohol, than opioids, than other drugs. It just works different. So you can consume marijuana and you can have a fairly high test result a week later, but not be high, not be affected by the drug, particularly if you use it quite a bit. And there just hasn't, we'll get there, but there just isn't a test right now where someone can say, using an objective biological standard, you've got too much marijuana, you've got too much THC in your blood, you can't be here. We don't have that yet. And I know that's very unsatisfying to you guys, but that is the truth. Okay, that's all I've got. And that was actually, I've got 10 minutes, 11 minutes left, so perfect time for questions.
So, how would we legally terminate somebody if the only way it seems like you could do it is if they were to admit that they shouldn't have been under the influence while operating machinery?
All right, so here's the portion of my talk where I say, I cannot give legal advice. Don't blame me if what I say is wrong. But here's my take on it. You guys are allowed to have your drug policies, okay? And if your drug policy says that if someone's over a certain level and they can't work for you, it's a non-discriminatory policy. It applies to everyone. And if it's, look, we're zero tolerance. You can't have any marijuana. We don't care if it's medical. We don't care if you have a medical card. You can't work here. That's just our policy. That's fine. There's nothing illegal about that. Now, so you're like, oh, well, that's a great answer. Let's take that to the bank, right? Well, here's the problem that I foresee. Someone comes into you, they haven't had an accident. They haven't had a test. But they come into your office and they plop down their medical card and they say, I have a medical condition, I need medical marijuana to treat that condition and I need accommodation. They use the secret word. What do you do then? I need accommodation and I need an exception from your drug policy. That's a tough one. I think the answer is easy for you guys. You pick up the phone and you call your lawyer. But what the lawyer does, I don't know. Because we don't have an answer legally in this state or in most states on how that plays out. Do you have to accommodate someone's, you could call it a disability, you could call it a medical condition. Do you have to accommodate that one? Are you required to accommodate that? Or is it just the right thing to do to accommodate that? If the accommodation requires you to allow them to be at work with a certain level of THC in their blood. Now, that's going to be, as you guys can probably figure out, that's fact case specific. If they're operating a truck and it's a federally DOT regulated thing, no. The federal government's not going to be okay with that. But I could see scenarios where you have an office worker or something and it's not going to be dangerous to anyone, where they could have a pretty good argument on that. So that is a lot less wishy-washy than usual for me as a lawyer, so you guys should be happy.
How does this affect the home health hospice world and having nurses come into their homes and making sure that they do have their medical card and they're not just recreationally using when we're there?
Well, I would be hesitant as a home health aide or nurse or what have you, healthcare worker, to take on too much of a role that I don't need to take on. So let's say you're in there for someone who has let's say it's a non-lung related disease. You see indications that the person is smoking marijuana. It's not affecting your job. You're not the caseworker. You're just there to do such and such and so and so. I might ignore that because I don't want to take on the responsibility of law enforcement or something else. Yes, I see something that's potentially illegal going on. I know the person doesn't have a medical card, but do I really care? Do I want to take on that responsibility? So the only other thing I can tell you is you're way too anxious to follow up, so I'm scared. But the only thing I tell you is if they do have a medical card, they have the right in their home to consume under the Constitution. So that makes it kind of easy, I think, for you guys, that they have a constitutional right. There's nothing anybody can do about it, right or wrong. And if they do, even if they do have some kind of health problem that you're thinking, this is not a good idea, you can tell them that, but legally there's nothing you can do about it.
And so if we're in the home to do medication management, that piece there they would have to have their medical card. They would have to do those things. And as a mandated reporter, we don't report that to anyone, is what you're saying.
Well, no, that sounds terrible. I would never say that. If you have a legal obligation, if you feel you have a legal obligation to report it, then you should report it. I'm just cautioning people on taking on obligations that they don't feel like they have, but they're trying to do, no good deed goes unpunished. That is a immutable law of the universe. Now, I'm not saying don't do good stuff, but you're going to pay for it, right? So you may just think twice about that. But you bring up a great area for lawyers. I mean, look, the great thing about medical marijuana, there's going to be so much work for lawyers. We're going to make so much money, guys. And we like money a lot. But long-term care facilities, what do you do there? That's a sticky wicket, It just keeps going in the healthcare industry. Hospital rooms. I mean, at some point it becomes easy. Like a hospital can say, no, you can't do that here. We're not going to let you do that here. But recently, 6 months ago, there was a hospital that got in trouble with the public and the media because they reported cannabis use, right, in this region to law enforcement. Law enforcement came and arrested the guy, and he was terminally ill. And his argument, which I think is a pretty good one, is, screw you guys. I'm doing this. I don't care. So attitudes have changed. I've been litigating for 20 years. For the first 10 years of my career, I was a criminal defense attorney. I walk into cultivation centers now, and the first thing I think is, 10 years ago, you guys would have been going to prison for the rest of your lives, federal prison, and nobody would have batted an eye, and they would have called you a bad dude on the way. That is not the public's perception anymore. The public perception now in Missouri and in other states is, this is my right. And you, government, state or federal, have for too long oppressed me and taken this away from me. And that's wrong. And if you dare try and interfere with my ability to consume this plant, I will yell and scream, because the public feels now that they have the right to do this. It's a complete 180. It's kind of funny. Years ago, I got a lot of guff for representing drug dealers. Now I get accolades. Like, oh, you were a social justice guy. Like, no, I was a criminal defense attorney. It's so funny the way the world has changed on this topic.
I'm glad you brought up the rights aspect of it, because it kind of tails into my question, which is, so given that it's a right in Missouri to use medical marijuana, and assuming it's going to be a right to consume it recreationally soon, does that also imply that there's a certain degree of personal responsibility, or that there should be some allowance for that in the workplace? And here's what I mean by that. As a company that regularly drives DOT trucks and operates heavy machinery and equipment, we have fall hazards. For instance, workers' compensation. The employer is, to the greatest degree possible, liable for almost everything that happens while an employee is employed, while as an employee is performing activities on behalf of our company. And so given that it's a right and there's a lot of personal responsibility, should there be some kind of personal liability if that individual chooses to use marijuana and has an accident at the job site, where the employer is no longer liable, but instead it's the individual should be liable? For instance, we have certain certifications, professional certifications in various industries, right? For a gate operator, the installer of that, for whatever reason, separate from the company, can be held personally responsible if somebody is injured because of an incorrect installation. And so I'm just wondering, is there anything presently in the law or any plans to institute something like that? Or how can we as employers advocate for something like that, to where we don't have to be responsible for individuals' personal choices?
Okay, so you gave me a choice of questions to answer there. So I'm going to pick the one I want to answer, which is, what's the state of the law right now? All right, and it's a great question, because you're right. The liability that employers have for employees hurting themselves, for hurting co-employees, for things going very wrong very quick, you guys are responsible for all of that legally, right? Under workers' compensation law for the most part. So there is a law, there is a rule on this, there's a statute on this that says that if you are under the influence of a non-prescription drug, and that's a term, non-prescription drug, at work, and that is the cause of the accident, then your employer is not responsible for that, okay? So.
Okay, will you say that again?
Sure. I'm not going to quote the statute because it's not in front of me. So just with that disclaimer, I think I'm doing pretty good. I'm not a workers' compensation attorney, but there is a statute, and I don't know what it is, I don't know the number, but it says that if you're under the influence of a non-prescription drug and you cause an accident, it is presumed that that accident was a result of you being under the influence of the non-prescription drug. And therefore, the liability on your employer is lessened or eliminated because of that scenario, all right? So you've got Frank. Frank is prescribed opioids. He's been very clear with his employer on what's going on, and you guys have worked it out. And Frank accidentally takes too much one morning, and Frank causes an accident on a forklift, and someone dies. Employer is responsible for that, all right? Switch out opioid for medical marijuana. Who knows? Is it a non-prescription drug? Yes. It is. You're not prescribed marijuana, right? You get a certification that you have a condition, and then you willingly, voluntarily go out and buy it. There's no doctor that prescribes it to you. There's no treatment plan that you're under. So technically, yes, it's a non-prescription drug. Is it illegal? Which is, I think, the point, the spirit of the law was really supposed to be illegal drugs, not non-prescription drugs. What it's really trying to say is illegal. Yeah, it's illegal, right? It's a Schedule I federally illegal drug. So under that scenario, under that analysis, Frank is liable, employer is not. But it's legal in Missouri. It's actually, he has a constitutional right to do it. So we haven't had that case yet. That case will happen. That case will wind through the courts. I'm sure it will go to the Supreme Court of Missouri, and in their wisdom, they will probably tell me I'm completely wrong and my analysis is off. But I'll be interested to hear what they say, because in a fairness analysis, in a policy analysis, in a strict construction of the statute analysis, it could go either way. You know, I mean, the whole point of workers' compensation is the way it's supposed to work is the employer is supposed to get a break on these big judgments, these big verdicts, and have kind of a controlled, scheduled liability that they can predict. And in exchange, they take the fault piece of it out of the equation. That's sort of the exchange that's supposed to happen. That really breaks down in medical marijuana scenario.
Particularly when there's no test that can prove at the time that he was under the influence, right? I mean,
Correct.
marijuana is different than some of those other substances because I can send an employee at the time of an accident, which is part of our policy, to immediately be drug tested, and then we have specific results. But if there's a lag time between ingestion and, between the actual high or the effects and the test results, where does that leave us?
Right here. in a bad spot, all I can say is stick to your drug policy that you have, right? Not legal advice. Stick to the policy you have and enforce that policy as you normally would, unless you get some kind of call for accommodation. And does that solve your workers' compensation problem? No. You're still going to have to fight about that. But we fight about workers' compensation stuff all the time. Were they on their way to work? Were they driving home? Were they in the scope of, So it's just one more thing to fight about.
With all the states, so many states going to the medical marijuana and just open, do you anticipate federal government ever making that change? And if so, when?
Sure. I do not, is the short answer. That's actually good for the medical marijuana market in Missouri. It needs some time, some incubation time. And if we got hit by interstate trade, they can grow a lot of marijuana in California outdoors for very cheap, and it's pretty good. We can't do that here, so we really need some protectionism. But there are a couple of bills out there right now. There's the Safe Banking Act, which was passed by the House this year. It's sitting at the Senate. It will not pass the Senate because the Senate is not doing anything right now. They're just sitting on everything, including the Safe Banking Act. The Safe Banking Act would allow medical marijuana, or all really recreational marijuana facilities in states where it's legal to access banking. Right now, medical facilities or medical marijuana facilities in Missouri and really marijuana facilities all over the country have a very hard time accessing banks because they're federally regulated, and look, my company, Vertical Enterprise, is a federally illicit drug trafficking operation, according to the DEA. That's what we are. So banks don't like us. So that would solve that problem. But even that banking, it's called the Safe Banking Act, for God's sake. It's like, that doesn't even have marijuana in the name. It can't get through. There's another one called the MORE Act. There's the States' Rights Act. They're trying to deal with this on a federal level and deschedule. I don't see it happening. I talked to the NCIA, the National Cannabis Industry Association. They have a lobbyist who spends all his time in DC lobbying for this stuff. I talked to him about a month ago. I asked him the same question. He said, no, not going to happen. There's an election coming up. I think maybe even the Democrat side has come out against descheduling, the leading candidate right now. So there's a disagreement even on the what you call the liberal side, the progressive side, on what to do at the federal level. Quite frankly, it's pretty good for Missouri and for the industry in Missouri. I think you'll get, I certainly know that Vertical and my buddies in the industry don't want federal legalization. So we're just very happy with the system we have.
So if you anticipate recreational being passed,
Yes.
how does that affect the medical?
Okay, great question. That is also a very long amendment, so I can't really summarize it accurately, but I'll do my best. The idea is that it opens up the market to people who don't have a medical card. So anyone who's over the age of 21 can walk into a dispensary and buy marijuana, which we've already discussed is not really medical or non-medical, it just is what it is. So these dispensaries will turn from medical into recreational dispensaries overnight. There will be no new licenses issued. So we stick with the 350 licenses we've got. So supply will not increase, but demand will. So people like me and Vertical really like this thing. It's very good for us economically. And then they're going to add these, what they call micro-business licenses. And there'll be 48 micro-business licenses, and this is for disabled veterans or economically disadvantaged people can open up a business where they can have up to 150 plants, they can process those plants, and the idea is they can then take that inventory that they create themselves and they can sell it in their own small dispensary. That may not work. There is no social justice program yet in medical marijuana or in marijuana generally that has worked. They've all failed terribly, miserably, so this one probably will too, but that's a little add-on that is in this new 2020-128 ballot initiative. Other than that, the taxes are different. So if you go into a dispensary and you have a medical card and you buy medical marijuana, you're paying a 5% excise tax. If you go in and you buy recreational, you're paying a 15% excise tax. People from out of state can come buy it. It'll be good for the economy. Everything else is the same. Security regulations are the same. So there's going to be cameras everywhere and access cards and all that stuff. It just really opens up the market to recreational. So you'll go from, at best in a medical market, 5% of the population. That's high. It's very, very high for a state. In a medical state, 5% will have their card. We'll probably hit 5% in maybe 2 or 3 years. So in a recreational market, you're looking at 33% of the population that will buy within a 6-month period, and another 30% will consider. So you can see the growth is pretty good. That's it? I'm 10 minutes over. Thank you guys so much. I really had a great time. Thank you.